The courtroom went completely silent when Dr. Eleanor Vance took the witness stand. I was sitting at the defendant's table, though defendant isn't quite the right word when your own children are trying to have you declared mentally incompetent so they can control your assets. My attorney, a woman named Caroline Marsh who specialized in elder law and who charged $400 an hour I was more than happy to pay, had her notepad open and her pen ready. Across the aisle, my daughter Jennifer and my son Scott sat with their attorney, a man named Paul Drenner who wore expensive cufflinks and had the kind of smile that made you want to count your fingers after shaking his hand. They weren't looking at me. They'd barely looked at me since we'd walked into the courtroom 20 minutes earlier. The judge, Honorable Patricia Kowalski, a woman in her early 60s who'd been on the bench for 18 years according to Caroline, looked at Dr. Vance and said, "Please state your name and occupation for the record." Dr. Eleanor Vance. I'm a board-certified neurologist and geriatric psychiatrist. I've been practicing for 23 years. And Dr. Vance, how do you know the respondent, Mrs. Dorothy Brennan? I've been Mrs. Brennan's primary neurologist for 8 years. I see her quarterly for cognitive assessments and general neurological health. Judge Kowalski nodded to Caroline. Counsel, you may proceed. Caroline stood. She was 51, had been practicing elder law for 19 years, and had told me in our first meeting, "Mrs. Brennan, if you're competent, and I believe you are, I'll make sure this court knows it." Dr. Vance, Caroline began, the petitioners in this case have submitted affidavits claiming that Mrs. Brennan is mentally unfit to manage her own affairs. They cite memory loss, confusion, poor judgment, and inability to handle basic financial tasks. Based on your professional evaluation of Mrs. Brennan, do you agree with this assessment? Dr. Vance looked directly at Jennifer and Scott. Then she looked at the judge. Absolutely not, she said. Mrs. Brennan is 74 years old. She has age-appropriate mild cognitive changes, completely normal for her demographic. But she is fully competent, fully capable of managing her affairs, and frankly one of the sharpest patients I have. I watched Jennifer's face. She was gripping her purse so hard her knuckles had gone white. Could you elaborate? Caroline asked. Dr. Vance opened the file she'd brought with her. I performed a comprehensive cognitive evaluation of Mrs. Brennan 6 weeks ago, specifically for these proceedings. Mini-mental state examination. She scored 28 out of 30. That's well within normal range. Montreal cognitive assessment. 26 out of 30. Again, normal. Executive function tests, memory recall, problem-solving abilities, all normal for her age. She looked up from the file. Mrs. Brennan can tell you what she ate for breakfast 3 days ago. She can balance her checkbook to the penny. She reads the newspaper every morning and can discuss current events in detail. She manages her own medications, her own appointments, her own household. There is absolutely no medical basis for declaring her incompetent. Caroline let that sit for a moment. Then, in your professional opinion, Dr. Vance, is there any reason Mrs. Brennan should not continue managing her own financial and personal affairs? None whatsoever. Thank you. No further questions. Paul Drenner stood up for cross-examination. He looked confident. He shouldn't have been. Dr. Vance, isn't it true that mild cognitive impairment can progress rapidly in elderly patients? It can, Dr. Vance said. But Mrs. Brennan doesn't have mild cognitive impairment. She has age-appropriate cognitive function. But you said there are changes. Normal changes. The same changes you'll have when you're 74, Mr. Drenner. If you're lucky. Someone in the gallery coughed to cover a laugh. Judge Kowalski's expression didn't change, but I saw something flicker in her eyes. Paul pressed on. The petitioners have stated that Mrs. Brennan recently withdrew a large sum of money from her savings account, $50,000. Doesn't that suggest impaired judgment? Dr. Vance didn't hesitate. It suggests she wanted $50,000 in cash. Whether that's good judgment depends on what she did with it. Did you ask her? Paul's jaw tightened. That's not. Because if you had, Dr. Vance continued, you'd know she used it to pay off her mortgage early, which saved her approximately $11,000 in interest. That's not impaired judgment. That's excellent financial planning. I permitted myself a small smile. Caroline had prepared Dr. Vance well. Or rather, Dr. Vance had prepared herself, because that's the kind of doctor she was. Paul tried a few more questions. Each one fell apart against Dr. Vance's calm, detailed, medically backed responses. After 10 minutes, he gave up. No further questions. Dr. Vance stepped down. As she passed the defendant's table, she put her hand briefly on my shoulder, a gesture of support, of solidarity, of a doctor who'd seen this play out too many times and was done watching families destroy each other over money. Judge Kowalski looked at both attorneys. I'll hear closing arguments now, but I already knew how this would end. I could see it in Jennifer's face, in Scott's refusal to look at me, in the way Paul Drenner was already organizing his papers like a man preparing to leave. They'd tried to take everything from me by declaring me mentally unfit, and my doctor had just destroyed their case in 15 minutes. Welcome to Family Reckoning. I'm grateful you're here for this story. Let me know you're with me. Drop your state or country in the comments so I can see where this message is reaching. Quick note. This story contains fictionalized elements for dramatic and educational purposes. Any resemblance to actual people or events is coincidental, but the lesson here, that's as real as it gets. I wasn't born wealthy. I want to establish that right from the start. I was born in 1950 in a 2-bedroom apartment in Syracuse, New York, to a father who worked at the Carrier factory and a mother who cleaned houses for families who had more money than we'd ever see. I grew up understanding that money wasn't something you were given. It was something you earned, slowly, through decades of work and careful choices. I married Tom Brennan in 1970. I was 20. He was 22, working as an electrician's apprentice. We had Jennifer in 1973 and Scott in 1976. We lived in a small house in North Syracuse that we bought for $22,000 with money we'd saved for 4 years. Tom worked his way up to master electrician. I worked as a secretary, then an office manager, then eventually a bookkeeper for a small accounting firm. We lived modestly, saved what we could, put the kids through college, Jennifer to SUNY Oswego, Scott to RIT. Tom died in 2008. Heart attack. He was 60 years old. We'd been married 38 years. He left me the house, paid off by then, and his pension and about $180,000 in savings we'd accumulated over nearly 4 decades of not spending money on things we didn't need. I kept working until 2012. When I retired at 62, I had $340,000 in combined savings and retirement accounts. Not wealthy, but comfortable. Enough to live on, enough to handle emergencies, enough to leave something to the kids when I died. That was the problem, apparently. The kids didn't want to wait until I died. The first hint came in 2019, 5 years ago. Jennifer called me on a Sunday afternoon. She'd been calling more frequently since Tom died, which I'd appreciated at first, until I realized the calls always seemed to circle back to the same topics. My health, my finances, my plans for when something happened. "Mom," she said that Sunday, "Scott and I have been talking. We think you should set up a power of attorney. Just in case." "In case of what?" I asked. "In case something happens. You're 70. Dad died young. We just want to make sure someone can handle things if you can't." It sounded reasonable, responsible even, the kind of thing a good daughter suggests to protect her mother. "I'll think about it," I said. "You should also think about moving," Jennifer continued. "That house is too big for one person. What if you fall? What if something happens and no one finds you for days?" I looked around the kitchen where Tom and I had eaten breakfast together for 30 years, where I'd made school lunches for Jennifer and Scott, where I'd sat alone after Tom died and learned how to be a person by myself. "I like my house," I said. "I'm just saying a condo might make more sense. Easier to maintain. Safer." "I'll think about it," I said again. Jennifer called back 3 days later, and again the following week. Each time she brought up the power of attorney, the house, how I really should make these decisions now, while I could still think clearly. As though turning 70 had somehow compromised my cognitive function. Scott started calling too. He was less subtle than Jennifer. Mom, we need to talk about your money. How much do you have in savings? What's your monthly budget? Are you keeping track of everything? I'm 70, Scott, not senile. I've been managing money since before you were born. I know. I'm just trying to help. You know how easy it is for elderly people to get confused, to make mistakes. Elderly people. I was 70. I walked 3 miles every morning. I volunteered at the library twice a week. I could recite every medication I took, every doctor's appointment I had scheduled, and the balance of my checking account to the penny. But to my children, I was elderly, which apparently meant confused, incompetent, in need of management. In March of 2020, Jennifer showed up at my house unannounced with a folder full of documents. I made an appointment with an elder law attorney, she said. Next Tuesday, we're going to set up a power of attorney and maybe look at a revocable trust. It's important, Mom. You need to protect your assets. From who? I asked. From complications, from confusion, from making mistakes that could cost you everything. I looked at the documents she'd set on my kitchen table. Power of attorney forms, trust documents, papers that would give Jennifer and Scott control over my finances, my property, my medical decisions. I'm not signing these, I said. Jennifer's expression shifted. Mom, don't be stubborn. This is for your own good. For your own good. The phrase that precedes nearly every act of control dressed up as concern. Jennifer, I said carefully, I appreciate that you're worried about me, but I don't need you to manage my life. I'm perfectly capable. Are you? She leaned forward. Because last month you forgot my birthday. I had forgotten her birthday. She was right. I called 2 days late, apologized, sent a gift card. That's not dementia, I said. That's being busy. And last time I visited, you left the stove on. I was making tea. I turned it off when the water boiled. You left it on for 20 minutes, Mom. The whole kitchen smelled like gas. That wasn't true. Or rather, it was true that I'd made tea, but I hadn't left the stove on for 20 minutes. Jennifer had arrived while I was making tea and had decided that the stove being on while water boiled constituted evidence of cognitive decline. I'm not signing power of attorney over to you, I said again. If that changes in the future, I'll let you know. Jennifer gathered up the papers. Her face was tight. Fine. But when something happens, and it will, don't expect us to drop everything to rescue you. She left. I sat at the kitchen table for a long time after, holding my teacup and trying to figure out when my relationship with my daughter had become a negotiation over control. The breaking point came in September of 2023. I decided to pay off my mortgage. I'd been carrying it at 3.2% interest, low enough that financially, it might have made more sense to keep the mortgage and invest the money instead. But I was 73 years old. Tom and I had always talked about owning the house outright, free and clear, with no debt. So I withdrew $50,000 from my savings account, about a third of what I had liquid, and paid off the mortgage. The payoff was $39,000. I put the remaining $11,000 in a separate savings account for property taxes and home maintenance. It made sense to me. It gave me peace of mind. It was my money and my decision. 2 weeks later, I got a call from my bank. A courtesy call, they said, because my children had contacted them expressing concern about unusual account activity. Mrs. Brennan, we just want to confirm. Did you authorize a $50,000 withdrawal from your savings account? I did, I said. I paid off my mortgage. Okay, good. Your daughter Jennifer called and said she was worried you might have been confused or coerced. We assured her the transaction was legitimate, but we wanted to follow up with you directly. I thanked them and hung up. Then I called Jennifer. Did you call my bank? I asked. I was worried about you, Mom. $50,000 is a lot of money. I wanted to make sure you weren't being scammed. I paid off my mortgage. Without talking to us first? Mom, that's not normal. You should have consulted us before making a decision like that. It's my money, I said, and my mortgage. I don't need to consult anyone. This is exactly what we've been worried about, Jennifer said, and her voice had taken on that particular tone of forced patience people use when they're explaining something to a child. You're making big financial decisions without thinking them through. You're getting confused. You need help, whether you want to admit it or not. I'm not confused, I said, and I don't need help. What I need is for you to stop treating me like I'm incompetent. We're not treating you like, Mom, we're trying to protect you. From what? From yourself. I hung up. 3 weeks later, I received a notice from the county court. Jennifer and Scott had filed a petition for conservatorship, claiming I was mentally incompetent and unable to manage my own affairs. They wanted a judge to grant them full control over my finances, my property, and my medical decisions. They wanted to legally declare me unfit so they could take everything I'd spent 50 years building. I didn't cry when I read the petition. I didn't call Jennifer or Scott and ask them how they could do this to me. I didn't fall apart. I got angry, the kind of anger that doesn't burn hot and fast. The kind that burns cold and steady and doesn't go out until the thing it's pointed at has been reduced to ash. I called Caroline Marsh the same day I received the petition. She'd been recommended by Phyllis, the head librarian where I volunteered, whose mother had gone through something similar 5 years earlier. Caroline met with me the next day. I brought the petition, my bank statements, my medical records, and a list of every conversation I could remember where Jennifer and Scott had suggested I was becoming incompetent. Caroline read everything. Then she looked up at me with the expression of someone who'd seen this exact scenario play out 100 times and was tired of it. Mrs. Brennan, do you want to fight this? Absolutely. It's going to cost money. Court fees, expert witnesses, my fees. Probably $20,000 to $30,000 by the time it's done. I have the money, I said, and I'd rather spend it proving I'm competent than let my children take it by declaring me incompetent. Caroline smiled. Not a happy smile. The smile of a lawyer who'd just been given permission to do what she did best. Then here's what we're going to do. The preparation took 6 months. 6 months of building a case that would prove beyond any doubt that I was mentally capable, financially competent, and fully able to manage my own affairs. Caroline arranged for comprehensive cognitive testing. Not just the basic screening you get at a regular doctor's appointment. Full neuropsychological evaluation. 3 hours of testing spread across 2 sessions. Dr. Vance administered some of it herself. The rest was done by a neuropsychologist named Dr. Raymondson, who specialized in evaluating older adults for exactly these kinds of cases. I took memory tests, pattern recognition tests, problem-solving exercises. They asked me to recall lists of words, to draw clock faces, to solve arithmetic problems, to explain proverbs. It was exhausting and humiliating in a way that I had to prove my own competence to keep my own children from taking everything from me. But I did it. The results came back in writing. Dr. Chen's report was 12 pages long. The summary: Mrs. Brennan demonstrates cognitive function well within normal limits for her age and education level. Testing reveals no evidence of dementia, no significant memory impairment, and intact executive function. She is fully capable of managing her financial and personal affairs independently. Caroline also had me document everything. Every financial transaction for the past 3 years. Every bill paid on time. Every medical appointment attended. Every medication managed correctly. We created a portfolio. Bank statements showing consistent, reasonable financial management. A ledger I'd kept for 40 years documenting household expenses. Letters from my doctor, my pharmacist, the librarian, my neighbors, all attesting to my competence and independence. And then Caroline did something brilliant. She subpoenaed Jennifer and Scott's financial records. If they're claiming you're incompetent and they need to manage your money, Caroline explained, the court has a right to know if they're financially stable enough to do that. And more importantly, it'll show motive. The records came back 6 weeks before the hearing. Jennifer and Scott were both in significant debt. Jennifer owed $83,000 in credit card debt, and had recently taken out a second mortgage on her house. Scott had 2 car loans, student loan debt from his kids' college, and was 3 months behind on his property taxes. They weren't trying to protect me. They were trying to access my money because they needed it. Caroline added it all to the file. When we walk into that courtroom, she said, we're going to have so much documentation that the judge won't even need to think about this for more than 10 minutes. She was almost right. It took 12 minutes. After Dr. Vance's testimony, Caroline called 2 more witnesses. First, Dr. Chun, the neuropsychologist. He walked the court through my test results in detail. Far more detail than Paul Drenner wanted to hear. Every score, every assessment, every data point that proved I was cognitively intact. In my professional opinion, Dr. Chun concluded, there is no basis whatsoever for declaring Mrs. Brennan incompetent. She is fully capable of independent living and financial self-management. Second, Phyllis from the library. She testified that I'd been volunteering consistently for 8 years, that I managed the used book sale independently, including handling money, organizing inventory, and coordinating with volunteers, and that I'd never shown any signs of confusion or impairment. Mrs. Brennan, Phyllis said, looking directly at the judge, is one of the most organized, capable people I've ever worked with. The idea that she's incompetent is absurd. Then it was Paul Drenner's turn to present his case. He called Jennifer first. Ms. Brennan, can you describe the behaviors that led you to believe your mother was incompetent? Jennifer had clearly prepared for this. She forgot my birthday. She left the stove on. She withdrew $50,000 without consulting anyone. She's becoming isolated. She doesn't return calls promptly. These are all warning signs. Caroline stood for cross-examination. Ms. Brennan, you stated your mother forgot your birthday. How many times in your life has she forgotten your birthday? Just that once. And you testified she left the stove on. For how long? At least 20 minutes. Were you in the house at the time? Yes. So you saw her leave the stove on and didn't mention it until months later when you needed evidence for this petition? Jennifer's face flushed. It wasn't like that. You also stated your mother withdrew $50,000 without consulting anyone. Is she legally required to consult you before spending her own money? No, but... And you're aware she used that money to pay off her mortgage, which saved her $11,000 in interest? Yes. Does that sound like incompetent financial management to you? It sounds like a decision she should have discussed with her family. Caroline picked up a document. Ms. Brennan, according to these financial records, you currently owe $83,000 in credit card debt. Is that correct? Paul Drenner stood. Objection. Relevance. Your Honor, Caroline said calmly. The petitioners are asking the court to give them control of Mrs. Brennan's substantial assets. Their own financial stability is absolutely relevant. Judge Kowalski nodded. Overruled. The witness will answer. Jennifer looked at her attorney, then at me. Yes, but that's not... No further questions, Caroline said. Scott's testimony went even worse for them. He admitted under cross-examination that he'd only visited me 3 times in the past 2 years, that he couldn't name my current medications, that he didn't know who my primary care doctor was. But you feel qualified, Caroline said, to determine that she's incompetent? Scott didn't answer. Judge Kowalski delivered her ruling from the bench. No deliberation necessary. I've reviewed the evidence presented by both parties, she said. The petitioners have failed to provide any credible medical or factual basis for their claim that Mrs. Brennan is incompetent. The evidence overwhelmingly demonstrates that she is mentally capable, financially responsible, and fully able to manage her own affairs. She looked directly at Jennifer and Scott. Furthermore, I find the timing and motivation of this petition highly suspect. The petitioners appear to be more concerned with accessing Mrs. Brennan's assets than with her actual well-being. This petition is denied. Mrs. Brennan retains full control over her finances and medical decisions. She banged the gavel. We're adjourned. I walked out of that courtroom with Caroline beside me and my full autonomy intact. Jennifer and Scott left through a different door. I haven't spoken to either of them since. That was 14 months ago. In that time, I've done several things. First, I updated my will. Jennifer and Scott are no longer beneficiaries. When I die, my estate will be split between 3 charities: the Alzheimer's Association, the local library, and a legal aid fund that helps elderly people fight conservatorship cases. Second, I established a revocable trust with a professional trustee, not family. If I ever do become incompetent, a neutral third party will manage my affairs according to my wishes, not theirs. Third, I wrote letters to Jennifer and Scott. I told them that I loved them, that I'd spent 50 years building a life and saving money so I could leave them something, but that their attempt to declare me incompetent had severed our relationship permanently. Jennifer wrote back once, a long email explaining that they'd only been trying to protect me, that I was being unreasonable, that I'd regret this decision. I didn't respond. Scott never wrote at all. I'm 75 now. My health is good. My mind is sharp. I still volunteer at the library. I still walk 3 miles every morning. I still manage my own money, my own life, my own future. And I will continue to do so until the day I actually can't, at which point professionals I've chosen will step in. Not children who saw me as an ATM with a heartbeat. If this story reached you, I need to hear from you. Leave a comment. Tell me if you've been through something similar. Tell me if you're afraid your family might do this to you. Tell me where you are in your own story. Here's what I learned at 75. 1. Document everything. Every financial transaction. Every medical appointment. Every conversation where someone suggests you're becoming incompetent. You'll need it if they try to formalize their claims. 2. Get cognitive testing done while you're healthy. Establish a baseline. When someone accuses you of declining, you'll have evidence showing what your actual cognitive function is. 3. Never sign power of attorney under pressure. If your children are pushing you to sign over control, just in case, ask yourself what the rush is. If it's legitimate planning, it can wait until you've had time to think and consult an attorney. 4. Understand the difference between a power of attorney and a conservatorship. POA is something you grant voluntarily. Conservatorship is something imposed on you by a court. Know your rights for both. 5. If someone files for conservatorship, fight it. Don't assume the court will see through it. Courts see these cases all the time, and without proper legal representation, you can lose everything. 6. Your children are not entitled to your money while you're alive. Full stop. You earned it. You decide what happens to it. If they can't accept that, they've told you exactly what your relationship is worth to them. 7. Find an elder law attorney before you need one. I was lucky I found Caroline quickly. Many people aren't. Research attorneys in your area now. Know who to call if this happens to you. These stories aren't easy to tell, but I tell them because elder financial abuse is one of the fastest growing crimes in America. And most of it is committed by family members who believe they're entitled to their parents' assets before their parents are dead. You're not entitled to anything. Not while your parent is alive and competent. And if you try to take it by declaring them incompetent when they're not, you deserve to lose every dollar you thought you'd inherit. Somewhere out there is someone whose children are circling, asking too many questions about money, suggesting it's time to get affairs in order, pushing for power of attorney. Trust your instincts. If it feels like a grab for control, it probably is. Protect yourself. Document everything. Get tested. Hire an attorney. And if they file that petition, fight them with everything you have. I did. At 74. Against both my children. And I won. So can you. If this reached you, share it with someone who needs to hear it. Subscribe to Family Reckoning so you never miss a story like this. Comment below. Tell me your experience. Tell me what you're protecting. Tell me how you're fighting back. Thank you for staying to the end. It means everything. One final note. Some elements of this story are fictionalized for narrative and educational purposes. If that's not your style, I understand. But the core truth, that you can be declared incompetent by greedy family members and still fight back and win, that's real. that's happening every day, and it's something every older adult needs to know how to protect themselves against.